When police in Maryland arrested and charged this man for second-degree felony assault in 2009, they had no reason to suspect that he might also have been a rapist. That is, until officials took a DNA sample from Alonzo King by swabbing his cheek and running it through a national database. That sample linked him to an unsolved rape 6 years earlier. King was convicted and sentenced to life in prison. But then a Maryland court said they had to let him go. Why?
And the Maryland Supreme Court looked at the evidence and determined that because the police had not obtained a warrant to obtain that DNA sample, they could not use the evidence, and therefore the conviction was overthrown.
King's case is now headed to the Supreme Court. Justices will decide whether DNA can be taken from someone who has not been convicted and used to investigate other crimes.
DNA is very powerful.
Mark Rotenberg helped write several briefs on privacy issues to the Supreme Court, including King's case. He says the case violates the Constitution.
The Fourth Amendment says that those searches have to be reasonable and typically done pursuant to a warrant. And as I said, in this circumstance, if you don't have a warrant for Mr. King, it's really not clear under what circumstances you could require a warrant for anybody. And that's why we think the Supreme Court should uphold the decision that the Maryland Supreme Court reached.
But the state argues taking a DNA sample was reasonable and is vital to solving serious crimes, preventing further crimes, and exonerating innocent individuals. Justices are expected to make a final decision before summer. Nicole Grether, The Associated Press.